I would start this discussion section, if I may, and if I can abuse with my position as the chair in this panel. I would have several questions, but I chose one, and this goes to Katerina. You have mentioned that there is a so-called material core of the Constitution of Slovakia, and this was made by the Constitutional Court of Slovakia. This is very similar to the Hungarian case. In Hungary, in the early 90s, the so-called Sejm Court formed the doctrine of invisible constitution, and we Hungarians don't know what invisible constitution exactly means. Do you know what the core of the Slovak constitution exactly? What does it mean?
Thank you for the question. Yes, there's a decision of the Constitutional Court that specifies the values that are, according to the court, a part of that material core. And these values are, for example, democracy. What it actually means, of course, that requires definitions then as well. There's a list of values that the court seems to be a part of that form the material core of the Constitution. The discussion is whether I haven't commented my last slide, but there's the discussion that actually whether the material core cannot be supported by the text, because otherwise there are opinions that it sounds very like mysterious concept, that what you are actually asking what it is, the material core. But there is a decision that this should be the list of, I think, 10, 12 values that should be perceived as the material core. Actually, you mentioned János mentioned the dissemination event. We had the dissemination event upon the material core, 2 dissemination events that were organized by our faculty. The first one concerned the presentation of the material core by the judge of the Constitutional Court. I have already sent the link and the English subtitles, and now we are working on the translation of the lecture of scholar about the line of the decisions taken by the Constitutional Court of the Slovak Republic in relation to the material core, and how as if the ping-pong table tennis was played between the Constitutional Court and the National Council. And the last word till now was given by the National Council, because it has limited the authority of the Constitutional Court. As I've said, its competence to decide upon the conformity of adopted constitutional acts with the Constitution, and now it is actually as if it is upon the Constitutional Court to decide whether such a statutory act might be in conformity with the Constitution itself, and what might be the reasoning then, whether they may actually use the material core. I don't think that the actual composition of the court might go that way. Oh, maybe I'm wrong. We'll see. But in general, the material core is about the values.
Okay.
That's why I was
the Constitution in Hungary. So it's a very ambiguous term.
Yes. For the beginning, we've got the list, and we'll see how the Constitutional Court will apply the list. So there are 4 important decisions within that line, where the Constitutional Court tried to somehow to define the concept. and the last one defined the list of values. And that's why I was so pleased to read the email about the journal and looking for the title about the law and non-legal values, for example, or law and values. Because as for the Slovak Constitutional Code, it is very actual topic.
Okay. Thank you very much.
A moment.
The floor is open. Professor Szilágyi?
Yeah, because Professor Smigova referred to a title of journal. Yes, I would like to explain this note because we are about to establish a new English language journal, and now, for example, in the professors' network groups, we have a kind of conversation about the title of this new journal, scientific journal, and one of these potential title was Law and Values. I hope that in some days we can send you the last list about the potential titles of the journal.
Oh, thank you. The closing of the conference is approaching, but I think we do have time for one or two questions. If you have, the floor is open. If you have questions, just ask. But it's not obligatory, so if there is not, I yield the screen to Professor Szilágyi, who will close the conference, who will make some remarks. Smigova, Professor Smigova. Yes.
Well, I just wanted to, if you were interested in the principles of values that I may specify, because I was general, that principle of legality, principle of sovereignty of law, principle of democratic legitimacy, principle of human dignity, principle of equality, principle of freedom, protection of all those values. And the code again specifies those values in previous case law. So that's the reasoning in the reasoning within the own case law of the Constitutional Code. I just wanted to specify it much more because I realized that in a way, I haven't answered the question whether there is something more specific. So these are the values that the Constitutional Code of the Slovak Republic sees as the material core of the Constitution.
Okay, thank you. Professor Tanya Karakamiseva-Jonevska. We can't hear you. We can't hear you.
Oh, sorry. About your comment, Katerina, I would like to share with you that actually those values are part of the Venice Commission Rule of Law checklist. And we are always running in the same circle, protected the same values, but in different national perspectives. And this is why I'm saying that from the beginning of my presentation, I said that we need some systemic theory where we can talk in the same manner and same language, not to be disturbed by those different kind of interpretation of the values, Venice Commission values, National Constitutional Court values, I don't know, UN values, European Union values, but to have one common systematic theory where we can have a unique, uniformed way of thinking. And that's why I say that in the beginning, at my conclusion, actually, I said that we have to rethinking the legal thinking about the protection of these legal values in European level and also in national level, if we want to have some kind of success as a legal scholars. Thank you.
Thank you. Yes, I think too that there are interconnections between the national and the supranational levels. Anything else? Do you have some questions?
I have maybe one comment. I'm not part of this research group, but I did find the time to join, and I really enjoyed the presentations. So thank you so much. It was very, very valuable to me personally. And as David mentioned, I agree that the countries of Central and Eastern Europe are approaching this question differently than, you know, the Western countries. And I think it's natural given our common history and the problems that we are facing due to that history, you know, the question of minorities, the prosecution of crimes committed under the communist regime in a lot of cases. So I think it's completely natural that our approach to human rights is, or our interpretation is a little bit different. To be honest, you know, I know there's a lot of backlash, for example, when on Hungary's position on mandatory imprisonment or, you know, parole only after 40 years and so on. But I think that these deficiencies that maybe we have are not necessarily deficiencies. And even if we look at Western democracies, it took them, you know, a couple of decades to start regularly relying on judgments of the Strasbourg court. So I think it's really interesting, and I think this is the value of this professors network, really, to have these countries come together and talk about our positions, because it's not very often heard.
Yes, thank you. Professor Segla?
Sorry, maybe 2 questions, because I'm not sure whether I've got properly from 2 presentations. These are not comments, but really particular questions. Just to make sure, as for the Polish system, Piotr, have I got it properly that the president shall not refuse, so the president cannot refuse to sign an act if the conformity has been approved by the Constitutional Court? Is it so?
Yes, it is so directly in Polish Constitution.
Okay, thank you.
You can ask, but the answer is binding.
All right. Thank you very much. So it's directly in the Constitution. And then the Serbian system, if I may the question. So then the Constitutional Court is not bound by the framework of the complaint itself. So as if the Constitutional Court as a special type of court might broaden the object of the complaint. Have I got it properly?
There is a specific situation in a constitutional court of Serbia. One side is a constitutional complaint, but the other there is a different kind of complaint that is not constitutional complaint, and that is regulated directly in the constitution. That is complaint of membership of parliament. For example, if you don't have a confirmation from the parliament and you got a new mandate as a member of parliament, and then judges and prosecutors have a right to complain to constitutional court, but that is not constitutional complaint. And another kind of complaint to the constitutional court is in hands of local local community, local self-government, and provincial government. That is a 5 or 6 kind of complaint.
Okay, thank you.
Okay, thank you. Any other questions? If not, then the word goes to Professor Szilágyi. The floor is yours. Please share with us some concluding remarks for this conference.
Thank you so much. Ladies and gentlemen, I would like to grab your attention for a few more minutes. First of all, it's worth repeating that I have an SMS from the Minister of Justice, and she drew our attention to the values of the EU funding fathers as a quite important direction. Nevertheless, for me, in this case, I could find a great potential in the case law of foreign judicial decision, as a potential source for the constitutional court. Some of you referred to this opportunity. For example, Professor Smigova mentioned that the Slovakian Constitutional Court prefers to refer to the Czech Republic decisions, maybe, and law. And I think that in our region, we have, not all, but in numerous cases, we have similar, values basis, and so on and so on. And maybe it could be a potential future of the development, the improvement of the job of the Constitutional Court to refer to each other in this region, not merely to German Constitutional Court and to the U.S. Supreme Court and so on, but to each other. Maybe it can be a message of our meeting. Our original plan was to organize a conference in person. Unfortunately, because of the pandemic, we couldn't do that. I hope that in the next semester, however, we can meet each other in person. At the end of this conference, let me offer my most sincere thanks for their contribution to all the group members of the Central European Professors Network. Of course, to the Secretary of State of the Hungarian Ministry of Justice, Professor Vieles from Poland, Professor Tanya Karakamiseva-Jovanovska, two representatives of our organizer partner institutions, Professor Peter Miskolc-Bodnar and Professor Peter Patolei. Furthermore, I would like to express my warm thanks for the effort undertaken by my colleagues in connection with organizing this conference, especially Rodriguez Herrera Atanasi and Gábor Katona. Dear participants, thank you for your work today. I hope you had a useful, fruitful, and at the same time pleasant event today. Thank you so much, and I am looking forward to meeting you at our next upcoming events.
Thank you.
Thank you. Bye-bye.
Bye.
Bye.